direct examination.
Dr. Stein, you indicated on cross-examination that in your view, the records that you reviewed indicated, and I think you said that there were 5 or 6 very brief, very transient psychotic times that psychotic symptoms were noted pertaining to the defendant. Was that accurate?
Yes, basically throughout her lifespan, as far as the records that we have noted from as far back as '98 up until 2011.
Is there any significance in your view that those psychotic symptoms were brief and transient?
Yes.
Explain why.
It's evidence that there was no pervasive psychotic disorder. Generally, when someone is bipolar and they have that with psychotic features, it's usually much more prolonged. I mean, it could be days, it could be a week until they're heavily treated, medicated, and they're very bizarre in the sense that they're very manicky at the time, and they, as one example, they're walking down the streets of Miami because they believe that they are a princess and they are being followed, or they're meeting the king or something like that. The fact that these were really rather minor, like some suspiciousness, it would be noted maybe one time and then you wouldn't see it for quite some time, is significant in the sense that it did not appear to me to be anything that is consistent with a major psychotic episode. That doesn't mean that there wasn't some degree of a psychotic symptom, but you can have, for example, a depressive symptom, and it doesn't mean you're suffering from a depressive disorder. So that's the best analogy.
In your opinion, the fact that the records reflect in the defendant's history 5 or 6 incidents where psychotic symptoms were reported, does that necessarily mean at the time of this offense in 2011 this defendant was suffering from psychosis or in a psychotic state?
No, it doesn't. And I think one of the things that I had noted in my report is that this is someone who had been given a diagnosis before of bipolar disorder with psychotic features, schizoaffective disorder, bipolar type. I even saw once major depression with psychotic features. And that is not relevant at all to the period surrounding the alleged offenses. Whether she had a period where she had psychotic symptoms or even had a psychotic episode, which I didn't see an episode, but let's just say symptoms, that's not relevant to her mental state at the time of the alleged crimes. You have to look for, is there evidence of psychosis, hallucinating, being delusional, things of that nature at the time, before, immediately after, and I didn't see that. I did not see any evidence of that.
Ms. Bradley spoke with you about a November 2008 letter that the defendant wrote to her daughter where she discussed her mental illness.
Yes.
Do you recall, can you tell the jury whether your review of the records revealed whether there was any similar expression of heartfelt emotion towards her daughter at or near the time of the murders?
I'd have to take a look at the journal to see if there was anything in there where she might have said something like, they're good kids or something like that, but predominantly When you look at the USF psychiatry records, you look at Winmore records, she is very distraught, very depressed about, very angry about how she feels her daughter is treating her, disrespecting her, being very mouthy, having a very poor attitude. In fact, she did talk about how she had heard, and this is in the interviews that I did with her, that she had actually heard her daughter on a phone conversation with Mr. Parker saying, you should divorce her. Now that was back in the summer of 2010, but I would say predominantly they were very different emotions towards Calix close in time than that fall of 2008 letter.
I'm going to show you again State's Exhibit number 33K, the portion of the journal that starts, the lower half starts with MON, that I believe defense counsel addressed with you, where the defendant wrote, I reread everything, I don't even understand my thoughts, my own thoughts I put to paper. And then you ask me if you have an opinion as to whether or not that journal entry right below the capital letters MON are any indication in your view about her ability to reflect and reason, at least at the time that that journal entry was made.
I have an opinion about that.
And what is that?
My opinion is that it does support her ability at that time to reflect upon the fact that she had been drinking and using or misusing narcotic pain medication at the time of her earlier entries, and that she says in here that she she sounded drunk, she sounded uneducated, as Calix was telling her, that's what she had said, and that she was using the medicines and the alcohol to medicate her emotional and physical pain. It does show, among other pieces of evidence, the ability to have that cognitive reflection, that wherewithal.
Thank you, Dr. Stein. I have no further questions.
May this witness be excused?
Yes, sir.
Yes, Your Honor.
Ma'am, you may step down and you're free to go.
Okay.
Turn to the state.
The state of Florida has no further witnesses. We rest our rebuttal case.
All right, I'll have counsel step up for a second. Ladies and gentlemen, members of the jury, I'm going to be sending you home for the evening. Now, you may recall I explained to you at the outset of these proceedings how a trial is conducted. You've now heard all the evidence that will be presented in this case. We remain in the course of trial. When you come back tomorrow, we'll proceed, as I explained about the progress of the trial, to introduce counsel to their closing arguments. Following those arguments, you'll receive instructions on the law. Following those instructions, you'll retire to deliberate. What that means is, I've explained again the process, that means that we are still in the course of trial. So as I send you out this evening, I'm going to remind you of those instructions because they strictly apply. Now we're going to set the time. I told you we're going to be considerate of your time. We've got a variety of matters to address, including some matters first thing in the morning that are totally unrelated to this trial. So we're going to have you back in the morning at 9:45 a.m., 9:45 a.m. And we know back means to come into courtroom 53 over there where you've been assembling. So we'll have everyone here at 9:45 tomorrow to proceed. I'm going to ask once again that you get plenty of rest, get to bed early so you have plenty of rest so you can be completely alert and attentive as we continue these important proceedings tomorrow. Again, give yourself plenty of time. Got a little extra time in the morning, but give yourself plenty of time so we can be here timely, be considerate of everyone's time, and get that started. We're in the course of trial. You're not to discuss this case among yourselves. You're not to discuss it with anyone else. You're not to allow anyone to discuss it with you or in your presence. Once again, if during this break anyone attempts to say anything to you or in your presence about the case, that's when you tell them you're on the jury trying the case. Tell them to immediately stop. If that person persists, you leave them at once. As soon as possible, you're going to tell one of the bailiffs who in turn will advise me. I'll remind you this case must be tried on the evidence presented in this courtroom in your presence, in the presence of the attorneys, the defendant, and the judge. You're not to conduct any investigation on your own. You're not to visit any places that may have been described in the evidence. You're not to read nor listen to any reports about this case from any source whatsoever. Not to speak at all when the attorneys, the witnesses, or the defendant about any subject to your deliberations are finished, and not to do any sort of research, gather information about, or communicate about the case or the people or places involved through any means, or your jury service, through any means, including all those electronic devices out there. With that reminder of our important instructions, we'll see you at 9:45 in the morning.